Hello everyone and welcome to this month's Newcastle Discover, the latest in our Discover series. My name's Lily Moore and I'm Alumni Engagement Manager here at Newcastle University, and I'll be the host for today's event. As always, a massive thank you for joining us today. Having a will ensures that you're in control of what happens to your money, property and possessions after your death. But research shows that 5.4 million adults don't know where to begin when it comes to writing a will. Joining us today is Lydia McCaslin, Head of Wills, Trusts and Probate at Minkoff Solicitors, and she'll be providing us with an insight into wills, power of attorney and legacy giving, and hopefully answering all of your questions that you have around this topic today. So without any further ado, I'll hand over to you, Lydia.
Thanks, Lily. So yes, as Lily said, my name's Lydia. I am an associate solicitor at Minkoffs. We're based in Jesmond here in Newcastle. I'm Newcastle alumni myself. I went to Newcastle University from 1996 to 1999. I did BSc in medical microbiology. So obviously I had a change of heart after I got my science degree. I wasn't a great scientist, and I then went to Northumbria University to do a common professional exam, a one-year conversion course to law. And then I moved to do my legal practice course, which even if I'd done a law degree, I would have had to do. And then I trained in the workplace like all solicitors do, did a training contract, and I've never looked back. And I've been working in wills, trust and probate law since 2005. So I've got quite a lot of experience talking to people about wills. And today that's what I'm going to do. I'm going to talk to you about wills. I'm going to talk to you about powers of attorney and hopefully answer some questions that most people have about these things. Many of us are guilty of putting our head in the sand when it comes to talking about these kinds of things, and I get it. Nobody wants to sit around talking about what will happen if they're old, infirm, die. But we're living longer as we're just living longer, and so we're not living as healthily as we had because we're living longer lives. The incidence of strokes, dementia, and loss of mental capacity, that ability to look after things for ourselves, is becoming more prevalent with our ageing society. And in my role, I see how that touches lives and how important it is to think about what we want for ourselves as we get older. Most people think that their friends or their family would be able to step in and make decisions for them, but that's not actually the case. And so it's wise to just do some planning ahead. So the first thing I'm going to talk to you about today really is wills. What is a will? I think everybody probably knows. It's a legal document and it enables you to state what you would want to happen to your assets, so your property, the money in your bank account, your personal belongings after your death. As Lily said at the outset, only 1 in 3 of the adult population in the UK has got a will. And if you die without a will, there's some laws, the laws of intestacy, and they provide who gets a share in your estate. The rules are complicated, and the specific details of how they work depends on the deceased's situation at the time that they die. But it's not uncommon to see people who don't know the deceased get a share of the estate. That could be someone you don't know, you don't like, you've never met. We quite often send money all around the world when someone's aunt, great aunt, cousin once removed has died. They've never known them, and it's a real shame because most people I speak to do have a specific wish about what should happen to their estate on their death, and it's a shame that they don't get a chance to write that down and let that happen. It's a common misconception that all of a married person's assets would just pass automatically to their surviving spouse. It's just not the case. Jointly owned assets would pass on death to a surviving spouse. So jointly owned bank accounts, for example, somebody dies. So I've got a joint account with my husband, say he were to die. The bank would just take his name off the account and I would continue to operate that account, same account number, everything. So that would pass. But solely owned assets might not. So if he's got an ISA, you can only have an ISA in your sole name. Shareholdings can only be in your sole name. Premium bonds, those kinds of things. They wouldn't automatically pass to me. That the law doesn't provide for that. Another common misconception is that people who live together as spouses but aren't actually married or in a civil partnership have the same legal rights as those who are. It's really important to just bear that in mind. A surviving partner who wasn't married just has no automatic right to inherit. And so, people in that situation really should be making a will to provide for their loved ones. If you leave a will, it gives you the control. You decide who gets what when you die. And it's arguably one of the most important documents you'll ever sign. So what would you write in a will? So in the will, you get to state who your executors should be. So the executors are the people who make sure what is in the will gets done. It's someone, personal people responsible for calling in your assets, paying your liabilities, and then distributing the remaining sum in accordance with what you've said in the will. There might be trust provisions in there, that we might become the trustees of those trusts. So it's a really responsible role. So you have to have a think about who should that be. Some people like to check in with their chosen executors and just check they'd be happy to act. But it's got to be someone who's capable of doing that. It fits with their lifestyle. So maybe they live in the country where you keep your assets. They're quite good with money themselves. You can trust them not to run away with it. Just to do things properly. There can be people that they can be beneficiaries of your estate. Some people think that they can't be, but they can. So, for example, a married couple would probably appoint each other as executors, even though that they're going to leave their estate to each other. You could also put your funeral wishes in there. You don't have to, but I think it's a kindness to those people you leave behind if you have stated in there, if you've not had a discussion as a family already, whether you'd like to be buried or cremated. Some people like to explain more, where would they like their ashes scattered, what music they'd like to be played at their funeral service. I tend not to put that finer detail in a will, but some people do. I might leave a letter alongside the will. But just a statement about burial or cremation. It does happen. People phone the office and say, oh, so-and-so's died. I've got to arrange a funeral. Do you know when they want to be buried or cremated? I would put out the will and have a look. So I think that's a useful thing to put in a will. I think that most people should make a will if they've got children, because you need to provide for those children. One thing I think we should always put in a will, stops some people doing it, but who would have legal responsibility for your children if both their parents were to die before those children were 18? So under the age of 18, they can't own anything. They can't, they need an adult to agree to go on a school trip or have a med. If one has that legal responsibility for the child, but if both parents were to die and leaving a child under 18, you can in your will say who should have legal responsibility. So not necessarily the person that the child would live with, but who will apply for their passport, who will consent them to having an operation, those kinds of things. So that's something that some couples cannot agree on, and they make that stops them from going forward with a will. If you can't agree, just don't put it in. Don't not have a will, but it's something that you can put in your will, and it is useful. And then another thing is that a will, if you don't leave a will and everything passes to your children, say, those children will take at age 18 by law. That's the age at which we become a legal entity and are allowed to own something. Most people I talk to think 18 is too young for children to inherit a lot of money and be in charge of it. And so we can have conversations with you about what we can do about that. So a lot of people say that their children shouldn't inherit till they are 21 or 25. They're just kind of popular ages of historically ages that we came of age. But you could put any age restriction on there. I once had a client who said that somebody shouldn't get anything till they were about, I think, 40, which I thought was a bit harsh, but people have got their reasons. So that's something to think about. Most people think 18 is too young, and we put an age restriction over that in there. There's opportunities for inheritance tax planning, and I'm not going to go into detail about inheritance tax planning. That's a whole other subject of its own. But there are opportunities in a will to make sure that you make the most of your allowances. There are certain ways we can structure things that make them tax efficient. So making a will is a good opportunity to look at that. Opportunities for care home fee planning. Quite often people write trusts into their will to kind of fence off part of their assets so they're not used to pay for care home fees. And again, I could do a whole seminar on that as well another time, because there's a lot to discuss there, but that's another thing you can do through a will. And providing for both sides of the family, I suppose. Often when a couple have children from former relationships, and they want to provide for their current partner, but also make sure that their children from a previous relationship also benefit, we can make some arrangement in the will, so we make sure that everybody is provided for. Also, we can write into trusts protecting vulnerable beneficiaries. So beneficiaries who might be disabled children, for example, or family members who perhaps are in receipt of means-tested benefits. If they are to receive an inheritance, it might take them over the threshold for receiving benefits. So we can do things to make sure that they're still entitled to their benefits, but they can also receive some money from the estate. And that's very useful because it can provide another fund to provide for things that they might need going forwards. People have told me in the past that it's not so much the money that the benefits brings in, but it's the other services that the people are entitled to, social services, involvement with the vulnerable person. If they get their means tested benefits. So that's really quite important to have a discussion around that and make sure that the will is providing for everybody in the right way. Lots of people tell me that they are too young to think about making a will, and that's for older people. But I think anybody who has got any assets or anybody that they financially provide for, a spouse, a child, whatever, should be making a will. And we say make your will now, and make the will that suits your current circumstances, and just keep it under review. So every 5 years or so, take your will out, have a look through it. But as personal relationships and finances change throughout your lifetime, update your will. We can't guess what might happen in the future. And so make a will now. And if you were thinking, oh, well, I might get married, or I might have children, or I might win the Euro Millions, whatever, we would just make a new will if those circumstances arose, and don't let that stop you making a will at this time. Do you need a solicitor to make a will? Strictly speaking, no, you don't. You can go to stationers and buy a will and fill in the gaps. But there are certain requirements for making a will valid. So I do recommend seeing a solicitor, and I recommend seeing a solicitor like myself who is STEP qualified or a member of Solicitors for the Elderly. So they are two recognised professional bodies. The members of those bodies have to have passed exams and proven that they know what they're talking about. So I think, that it's worthwhile getting their experience and advice. I have seen many instances over the years of poorly drafted or incomplete homemade wills that can often lead to unintended outcomes. So I think when you make a will with a suitably qualified solicitor, the chance of a problem or a dispute arising after your death is reduced. Disputes do arise more often when someone dies without a will. Certain people are entitled to apply to court to challenge the provisions made by the intestacy rules, the rules that take precedence if you haven't got a will, if they deem that to be unfair. So, for example, a long-standing unmarried partner would receive nothing under the intestacy rules, and they could make an application to the court to be awarded a share of the estate. It's a hugely stressful process for everybody involved, for the executors, for the intended beneficiaries, for the people making the claim. And so it's worthwhile spending some time talking to a solicitor about things that you can do to provide for everyone you're supposed to provide for, everybody who you want to provide for. And if you're not going to provide for somebody, things they can do to make the chance of a claim kind of lessen that chance, really. So that's kind of a lot about wills. And I think, as Lily said earlier, if you've got more questions on them, I'd be happy to answer them. But that's kind of a whistle-stop tour about what is a will and why you should make one and where you can go for help. But I would strongly recommend that you see a solicitor about those. So then I'm going to move on to talk to you about powers of attorney, because I actually think, whilst I think everyone should have a will, I think the lasting powers of attorney are actually more useful, because a will takes effect on your death. So you write your will, now you put it in the drawer, that's the last you think about it really. And it's after your death, you're not here to worry about who's getting what. But the lasting powers of attorney are documents that have effect in your lifetime, and so really are going to concern you more. A lasting power of attorney is a document that enables you to nominate one or several people, known as your attorneys, to handle your affairs in the event that you're no longer able to do that for yourself. There are two types. One covers financial decisions, including dealing with property, and the other type covers decisions about health and welfare. So what medicine should you take? What clothes should you wear? Where should you live? And even making decisions about your end of life treatment. To be able to use a lasting power of attorney, it has to be registered at the Office of the Public Guardian, so a branch of the court really. And we recommend that you make your lasting power of attorney, and as soon as you've done that, you register it so that it's up and running. Some people would only register them if they wanted to use them, but that registration process takes quite a long time. I think by law, the court has to allow 6 weeks from receiving an application before they register it. And that's in case somebody makes some kind of objection. But at the moment, there is a backlog at the court, and I think it's taking them 16 weeks to register them. So if someone has an accident and their attorney needs to start acting for them, they don't want to have to wait that 16 weeks period. So we would suggest make your power of attorney and get it registered immediately so it's ready for use. They differ a little bit about in how they use those. So the financial lasting power of attorney can be used if you have capacity. So not just if you don't have the capacity to make a decision for yourself, but if you had a physical reason why you needed some help from your attorney. So if you couldn't hold a pen and sign a check, which is show my age because nobody uses checks these days, but if you had a stroke and you couldn't grip the pen, or I don't know, you couldn't speak, you had a stroke and you couldn't use this power of speech, you might still have mental enact. Your attorneys could help you make those decisions and act for you. So go to the bank and withdraw some cash or pay a bill. The health and welfare lasting power of attorney can only be used if you don't have mental capacity. So whilst the person has got mental capacity, those decisions about their health and their welfare can only be made by them. But if they haven't got capacity, so perhaps they have dementia and they can't make a decision about where they should be living for their own safety, what medicines they should be taking, then in that instance, their attorneys would make those decisions for them. I recommend everybody who comes to see me, no matter what they come to see me about, is to make a lasting power of attorney. And again, quite often people say to me, but I'm too young. Well, we don't know what lies ahead, thankfully, for any of us. So yes, they are associated with things that we get as we age, loss of capacity due to dementia and Alzheimer's and things like that. But any of us could have a brain injury that meant that we were not able to look after ourselves, make our decisions. Personally, my father-in-law is currently in intensive care. He's totally got mental capacity, totally capable of looking after his own affairs, but he's been in hospital for 3 weeks, so we can't pay his utility bills because he hasn't done his power of attorney. There is a misconception again here that a spouse or a next of kin can make medical and care decisions on your behalf, but that's actually only the case if you've got a registered health and welfare power of attorney in place. And most of the time, most families, to be fair, muddle along just fine, because what the doctors and nurses want for the patient is the same as what the family would want. But if there is any disagreement, doctors and nurses saying we need to treat them this way, and the family is saying, well, no, that's not what they'd want. If they haven't got that power of attorney in place, there's difficulty. And so these are the court cases that you see that go to court, that you see in the press. We'll make a application to the Court of Protection to have a deputy appointed. Health and welfare attorneys are rarely appointed. The court doesn't like to interfere in matters of health and welfare unless it's a matter of life and death and they absolutely have to. But with the financial side of things, an application to for the Court of Protection to have a deputy appointed happens quite a lot to deal with money, and we see it quite a lot where someone's lost capacity and they need to move into permanent residential care and they can't sell the house because they haven't got the capacity to sign the paperwork. So it's too late for them to make a power of attorney, and what we have to do then is make an application to the Court of Protection to have somebody appointed legally to look after their affairs for them. We call that a deputy, so an attorney and a power of attorney, but a deputy if it's gone through the court. And that is not what anybody wants because it is complicated. There's an awful lot of paperwork to fill in. It's lengthy. It's currently taking about a year to get that deputy order from the court from the date that we apply. Often our clients pass away while we've done all the paperwork, we send it to the court. Before the court could deal with it, the person's died and it's not relevant anymore. And it's costly. The court fee alone is £371. You need a medical assessment of your capacity, the person's capacity. That's about £300. There's legal fees on top of that. And you have no choice who's appointed your attorney. Someone will apply to be appointed your deputy. So that might be a solicitor, it might be a neighbour, it might be someone you've never met, you don't know. And so you're better off making your power of attorney because you've got control over who you're appointing. And as I said earlier, health and welfare orders are very rare. Only 90% of those are not approved by the court because the court doesn't like to get involved. So that's why we think you should have a power of attorney. And incapacity is on the rise. Every 3 minutes, someone in the UK develops a dementia. And they're not all elderly people. It affects people of all ages. It's estimated that in 2025, there'll be 1 million people in the UK diagnosed with dementia, and that, including those who aren't diagnosed, that will be 1.3 million people, rising to 2.7 million people by 2050. Dementia is the biggest cause of death in England and Wales, and strokes and conditions like diabetes that can lead to increased risk of dementia are also on the rise. And of course, there's other reasons for incapacity, so alcohol and substance abuse, brain injuries following a brain trauma, motor neuron disease. I've got a couple of clients who we've put powers of attorney in place at the outset when they've just been diagnosed with motor neuron disease. So, there are real reasons for making these. One of my colleagues refers to them as insurance policies. She said you wouldn't think twice about taking out an insurance policy over your property, and you hope that you're never going to have to make a claim on it, but you do it every year. And that you should really be doing the same with powers of attorney. Make them, put them in a drawer, forget about them, but they're there just in case the worst happens. Who should be an attorney, I suppose, is something I should talk about. And it's usually a trusted family member. People rarely ask their friends, but they do. But you can select legal professionals to be your attorneys if you wanted to. What's really important is whoever you appoint as your attorney has to be someone that you trust. Any decisions that they make for you have to be in your best interests. But you are giving them a lot of power, the power to sell your house, to invest those net proceeds of sale, to use them. So, it's got to be someone that you trust to look after them. And that's where quite sometimes solicitors get appointed because some people don't have that trusted person in their lives. It says one of the next things I was going to talk to you about is when you should make a power of attorney. And I think I've made it clear that I think you should do it no matter what your age. But what's important is you can only make it while you've got mental capacity. So it's important to really plan ahead and get those wishes down on paper so that it's in place. All too often I'm asked to attend someone's parents to put lasting powers of attorney in place, but sadly that person no longer has capacity, and they just can't understand what the power of attorney is, and therefore I can't go ahead with it. Having said that, a diagnosis of something like Alzheimer's or a dementia wouldn't stop you putting a power of attorney in place, because as long as in the moment that it was explained to the individual what a power of attorney is and they could understand, and they can say what they want, then that's fine. It doesn't matter if after the appointment they forget having had the appointment. It's just at the time of giving the instructions and the time of signing the document, did they understand? So, and that shouldn't put anybody off who's thinking, oh, quick, act quickly before things get worse, and we will come out and we will see them and we will try and get them in place. The lasting power of attorney forms are available online, and they have purportedly been designed so that anybody can make them without the input of a solicitor. So that's great, they're there. I see lots of people who printed them off and come in and said, I don't know what to do with these forms, how do I complete them? Each form is 20 pages long, and we're all capable of filling in a form. But what you get from seeing a solicitor is our experience of how to risk them being flawed documents that won't get registered, or they're weak, or they sometimes find that with DIY ones. A self-made lasting power of attorney just might not consider all possible outcomes, and it might just be inaccurate and not quite what you want. And then it just causes strain when it comes to be used. It's just upsetting for the people trying to help you if they haven't got the paperwork just to be right. So an experienced solicitor would be able to help you set out exactly what you want and use the right terminology, and would also prompt you to consider things that you might never have thought of. I always feel a bit of a doom monger, in appointments with clients. They say, oh, this is what I want, and then I say, well, have you thought about this, and what if this happens, and what if they die, and what if this, and they're like, oh, I've never thought about that. But that's the benefit of having a solicitor and their experience, because we're experienced not only in setting up wills and lasting powers of attorney, but we also deal with the other side of things. So we administer estates when people have passed away, so we can see why the wills and the powers of attorney would have been helpful in lifetime. And we deal with those applications to the court, because people who haven't put the powers of attorney in place, or they've not been what they've needed to be. So for example, I am making an application to the Court of Protection at the moment to have a deputy appointed for somebody. She did have a power of attorney. She appointed the one who's most involved with her affairs. He died, and she needs to sell her house, but she's not got capacity. So if she had seen a solicitor, that solicitor hopefully would have said, why have you don't just appoint one attorney, appoint more, appoint them in this way or that way. And we wouldn't be in this pickle now, because although he's died, her other children would have been able to sell her house. Now she's moved into care. But that's not what she did. She made it herself. And now we're making an application, and it'll be a year before. She had a buyer in place, so it's going to be a year before she can be able to sell that house, because we need that order from the court to make that happen. So, that is where you get the benefit of using a solicitor, I think, to help you. So really, in conclusion, it's important that you make a will to help you control what happens to your assets on your death. I've never met a person who didn't have an opinion on that, but the only way they can make that happen is by writing their will. Those intestacy rules just don't suit most people. It breaks my heart to send thousands of pounds of owing to Australia to someone who's never met the person whose money they're taking. The lasting powers of attorney prevents leaving your finances and health and welfare choices to people who potentially don't know, don't like, don't trust. And so I really would just urge you to start thinking about what you want, seeking out an appointment with a solicitor, and preferably a step or a solicitor for the elderly qualified solicitor, and just having an open conversation. This is what I want. How do I get it all put in place? And that's what we're here to do. We're here to help. Back to you, Lily.
Amazing. Thank you so much, Lydia, for a really kind of thorough overview of the ins and outs of wills, power of attorney. It's just really useful to hear, and I've definitely learned a few things there. We have had lots of questions through both the chat and the Q&A function. So I'd like to just, obviously we've got the next sort of 20 to 25 minutes for Q&A, which is lots of time to get through all the questions everyone's asked, but please keep questions coming through as we're talking. We have had a number of pre-submitted questions as well, and actually some of these mirror kind of what we've already had in the chat function and in the Q&A, so I kind of grouped some together, and hopefully I can cover everyone's queries. So first question that was part of the pre-submitted questions but also has been asked quite a lot in this session, and I think you touched on it slightly, is just around costs. So what is kind of the typical cost for writing a will and all the rest of it? So yeah, if we should give a bit more information on that would be great.
Yeah, so you'll find that the costs vary quite a lot between solicitors. So some of them are super cheap. I would see a solicitor, so don't go for a will writer or bank service, which is probably maybe free or cheap, because you won't get a personalised service there. And when I say cheap, I'm talking £150 probably. Minkoffs charge for an individual's will, provided it's all fairly straightforward. So most wills from an individual will be like, I want to leave everything to my husband, and if he dies before me, to my 2 children in equal shares. Fairly straightforward. We would charge £350 plus VAT for that, and we're very much middle of the road. So you will find solicitors who do it for less, you will find solicitors who do it for more. For a couple, married couple, who want to leave something similar, nothing particularly complex, we would charge £600 plus VAT for the pair of the wills. But if we do small bespoke planning, so we might have some trusts in there for inheritance tax planning purposes or care home fee planning purposes, because they get quite complex, there's additional time required to explain them to you and to draft them, the costs are higher. And you would find that at any solicitors, but hopefully the solicitor would give you that information at the outset, give it to you in writing, and you would have to approve it before you went on and agree to get the work done. So that's a rough idea of the costs of wills. Lasting powers of attorney, we charge £350 per lasting power of attorney that we do. But if we were going to make both types for a couple, so that would be 4 lasting powers of attorney, we would reduce the cost. So it wouldn't be 4 times 350, because obviously there's an efficiency to be had in taking all the instructions at once and doing it all. And I think some firms charge an awful lot more. Some firms will charge less. We're, I think, middle of the road again. Again, you can do them yourself for free. You don't need a solicitor to make the lasting power of attorney. I would advise you see a solicitor, but some people don't, and the forms are available online. And I have to tell you that so I can sleep at night.
That's great. And just going back to kind of wills and the cost of wills, obviously you mentioned earlier, it's good practice to write an initial will and then sort of keep reviewing it every sort of 5-ish years. Is there a cost associated with reviewing it, or is that just kind of yourself personally reviewing it?
So if we were just doing a general review and nothing, we just checked that you understood what was in there and you're happy with it, and that was the end of it, we wouldn't charge you for sitting down and having that conversation with you. But if we needed changing, then there would be another charge for preparing a new will. Some solicitors will do what's a codicil. It's like a little mini will, and a codicil would just change something. So if you were changing the name of your executors, or you were increasing a legacy that you might have left, say the university a £500 legacy in your will, but you wanted to change that to a £1,000 legacy in your will, they could do a codicil that just gets attached to it and changes that part, and the rest stays the same. I'm not a fan of doing a codicil, I have to say, because I don't like the thought of there being 2 separate documents that might never marry up, and the will could get proved without the codicil. So I prefer to do a whole new will, and would charge you for a whole new will. But it's because actually at that 5-year point or whatever, we would take the time to go through the whole process with you again, to just double check that it actually we are writing a will that is suitable for you. God forbid somebody came forward and said, well, you know, they didn't have capacity on that day, or well, they didn't have £1,000 to leave me. We'd be at fault for having not checked those things with you. So we do tend to write a whole new will and charge again for a whole new will.
Great, that makes sense. And just on sort of kind of, obviously you mentioned about sort of who's the best person to go to, and obviously solicitors is kind of your best advice, but a few attendees have noted a lot of charities are offering will writing services, and kind of just what your thoughts are on that, and kind of, is that a route people should go down?
So they will be solicitors writing those wills, probably. We don't take part in those schemes. Because my experience is that the clients, because they're not paying for it, they often don't come back and complete their instructions, which gives me the heebie-jeebies, because I think, gosh, in their head they might think that they've sorted everything out and they've never actually come back and done it, and I don't like it. But yeah, the idea is that you give a legacy to a charity and you're given a will by a solicitor for free. So some of them most of them will be solicitor written, and they'll have firms behind them who do the drafting, but some of them will do it without meeting you and taking proper instructions from you and spending that time listening to you, because they're not making any money out of it themselves. But yeah, you know, just find out. I would just say find out who is writing the will. If there's a suitably qualified solicitor behind the scheme, then great, go for it. It's a great way for charities. Charities appeal every year for legacy giving that way. But a better way to do it might be to go and see a solicitor, have your will written, and in that will say, I would like to leave a gift of X amount to such charity. And that might be a better way of managing what your charity, making sure that the charity gets something, but also that your will's top notch.
Yeah, great. And obviously you just mentioned kind of legacy given there. I don't know if you could tell us a little bit more about that and how that all works.
So it is, people do like to continue to support charities that are supported in their lifetime through their wills. And whenever we meet with somebody to take their instructions, we ask them, would you like to leave a sum of money to anybody or any charity? So sometimes people will say, oh, I'll give £500 to each of my grandchildren. But a lot of the time I said, you know, charities that they've had some contact with during their lifetime, they will leave a gift to. And it's also a good inheritance tax planning point, because if you leave 10% or more of your estate to charity, you pay less inheritance tax on the overall estate gift, free of inheritance tax as well. So it's good, there's good reasons for doing it, selfish reasons as well as charitable reasons. Yeah.
No, that's great, thank you. The next sort of set of questions I'm going to try and group together slightly, because they all relate to a kind of similar topic about having assets in different areas and different countries, and how that applies to if you write a will in the UK. So our first question came from Paulina, and she pre-submitted this prior to the session. And she asked, if someone has material assets, so say for example property or bank accounts in another European country, are they allowed to add them to the will they do here in the UK, and will other European countries respect that will that's been completed in the UK?
It's a really complicated area of law. But having said that, our standard advice is to make a will here in England for your assets here. So a will written in England can only cover assets in England and Wales. So there are different laws in Scotland, there are different laws in Ireland. So it would just be England, it would just cover your assets here. Somebody who has assets in other jurisdictions should speak to a solicitor in that jurisdiction and probably make a will in that jurisdiction that relates solely to the assets in that country. And that's probably the best advice. And both solicitors, or if there's more than two, need to know about that there's a will, so that they don't mistakenly revoke the other country's will. So there's always a statement goes in. So I would write that this will is restricted, covers only my assets in England and Wales, and this will might revoke my former wills in England, but does not revoke any will I've made in France, Italy, Spain, wherever the other assets are. So that would be our advice. It does get more complicated, and I won't go into it here, but basically that's what you need to do: seek legal advice in whichever country you hold assets.
Yeah, that's great. That makes loads of sense. The next question I'm going to go to is from Michelle, and she also submitted this prior. It's just going back to LPAs and thinking about, so she wanted to understand a little bit more on LPA forms, about attorneys changing and substitutes. So essentially, how can you future-proof the LPA? And also having more than one attorney means you have to decide on how decisions can be made by them, and just wanted to hear a little bit more on that, if that makes sense.
Yeah, so if you appoint more than one attorney, you can appoint them jointly, so they'd have to make all decisions together, jointly and severally, where they can make decisions together or they can make them independently, or jointly for some decisions and jointly and severally for other decisions, which I think is just far too complicated. Our advice is that you appoint your attorneys on a joint and several basis. And that would mean that it's just flexible, because we don't know what the future holds. We don't know if, a son or a daughter is going to move abroad, or one of your attorneys might die, he might become bankrupt. Bankrupt can't be an attorney. So, it just kind of future proofs it a little bit by having a joint and several appointment of more than one attorney, I think. Can you remind me, what was the second part of the question?
And is there a monthly or yearly fee paid? Oh no, sorry, I'm reading a different question. Pardon me, let me just go back up. And also having more than one attorney means you have to decide on how decisions can be made by them. Was that the second part you were looking
at? So that's the joint and several. If they're joint and severally appointed, they don't have to make decisions together. They can make decisions independently of each other. So it doesn't have to be joint decision making. You can say in your power of attorney which decisions you'd like them to do together and which independently, but I think that overcomplicates things, because obviously at the time that it's written, you can't really anticipate the situation in which it would need to be used. And so it's best not to do that, just keep it quite general, actually, for flexibility, for changing circumstances over time. I hope that answers the question.
Great, thank you. And then just going back slightly around kind of thinking about choosing a solicitor to write a will. So Kate's asked in the chat, what happens if a solicitor goes bust or changes hands? Does the solicitor you choose need to be in the local area to where you live? And what would happen if you wrote a will in an area, but then you moved out of that area, for example?
Okay. So pre-COVID, we would have said, yes, the solicitor has to live where you do, because you need to meet them. The solicitor would want to see you, to see that you understand what you're doing. But nowadays, we do video calls. So actually, we make wills for people all over the place. So that's not necessary. If the solicitor stopped practicing, usually their will bank passes to another local firm, and the Law Society keeps a record of where they've gone. So it does happen, in Newcastle over the years, firms have closed down, and their will bank, solicitors tend to know, because we deal with the same people all the time, where the will banks have gone to. But if we didn't know, we would ring the Law Society and say, can you tell us which firm now holds this firm's wills? If they go bust, the Law Society takes that will bank themselves and looks after it. So that, again, you would just ask the Law Society where it is. Some people there is a national register of wills. So some people use that and register their will with this private company, but we don't at Minkoffs, because actually it's not compulsory, and so not every firm uses it, and so therefore I question how useful it is if everybody isn't. It's not a real register if not everybody's registered on it. Does that make sense? So you don't have to have a solicitor local to where you are, and if you move out of area, you won't necessarily need to update your will, but it would be a good opportunity to get it out, look it over. Whatever has caused that move there might have been just bigger change in your circumstances, and it might be a good idea to make a new will. And yes, see someone local, because it's nice to pop in, it's nice to have a personal connection, but you don't necessarily have to.
Yeah, No, that's great. So in terms of our next question, within the Q&A, I'm sorry, I don't know who's asked this question, but they've asked, could you explain a little bit more about how probate works, please?
Probate is basically a court order that proves the terms of a will. So when somebody dies, not everybody needs to get probate, but anyone who owns a property, for example, probably would need to get probate. So there's two steps to it. The first step is to account to the revenue, to HMRC. So you need to know what somebody had. They want to see a snapshot of what somebody had on the day that they died and how much it was worth and what it was made up of. So an account for the revenue is completed. And that is the executors kind of making sure that any inheritance tax is paid or declaring that there's none due. So that's the first step. And then the second step is presenting the will to the court and say, and the executors make a promise that they are going to fulfill their executor duties. And the court looks at that, and if they're satisfied that everything looks okay, they then issue a court order known as grant of probate. And that just proves that the executors are legally entitled to be dealing with things. So if you go to the bank and the bank should say, well, grant of probate, and you can hand it over, and then the bank knows that they can discharge their liability to anybody else. They can hand the money over and they're handing it to the right person. And it's most often needed to deal with property transfers. So if I died and my house was going to pass to Joe Bloggs on my death, my executors have to change the legal title to my name, from my name to Joe Bloggs's name. Joe Bloggs is going to want to know that legally, the people dealing with it have got legal right to do that. The grant of probate is that proof.
Yeah, great, thank you. The next two questions, I'm just looking at time, we've probably got time for another 2 or 3 questions, I think, before we'll have to wrap up. But just to note, if you want to keep asking questions, we will collect any unanswered ones at the end of this, so don't worry if we don't have time to get to yours today. But 2 questions around kind of thinking about being in a couple. So firstly, if you're in a couple, is it better to have separate wills or a joint one?
You have to have separate wills, so your will's personal to you, but what it's best is to see the same solicitor at the same time, and what you'll probably do is have mirror wills. So you've got a will each, but the terms mirror each other, and usually it would say, if I die, I give everything to my spouse, and the other will say the same, and then they'll have the same next steps. So from the second person to die, this is what I would want to happen, and the other person's will would say the same. So yeah, you'd have a will each in similar terms.
And Claudia has also asked in the chat around, so in the instance of a married couple with no children, where you just leave everything to your spouse, is it a good idea to have a second tier or provision in case, God forbid, something happens to you both at the same time? We would definitely say that. Yeah. So that's when I'm really cheerful in my meetings and go, well, what if you both die together? What if one dies one, then the next dies the next day? You know, we would talk to you about what would you want to do. So in that situation, couples sometimes say, well, we'll divide the estate on the second death in half, and we'll give half to my family and half to the other family. Or they might say, oh, to go to a charity or a couple of charities that they've supported in their lifetime or whatever. But yeah, it is a good, we call it a long stop provision. What would you do as a long stop should everybody die? Yeah, great. And Tony's asked in the Q&A function, one of the witness signatures on their will is a series of squiggles, which the witnesses insisted is his signature, though you can't see the name in it. His wife, the other witness, has clearly written her name. Does this invalidate an otherwise valid will if the signature does not clearly show a name? No, it's usual to have a signature and then the name printed underneath it, and then the address and occupation of the witness. But as long as it has been witnessed, the technicality is it has to be signed, it has to be dated, it has to be signed by 2 witnesses. That's it. So as long as it is signed by a witness, it doesn't matter that it's not legible. Great. And I'm going to squeeze in 2 more questions, if that's okay. Sure. We're still getting lots and lots through, so I'm sorry I won't be able to answer everybody's, but we'll do a couple more and then we'll bring it to a close. So in terms of just a bit of kind of technicalities, so around sort of who can be witnesses and that sort of thing and executors. So first question, can an executor also be a beneficiary? Yes. Okay, great. And can you just clarify, a will needs 2 witnesses to be signed off who aren't named in the will, or would a lawyer be one of those signatures?
So usually we do it in the office, a lawyer would do it. So if you came into my office to sign your will, I'd be one of the witnesses, I'd get a colleague to be the other witness, and that would all be fine. Rarely we have to send it out, someone can't come into the office or they don't live locally, we would post it out and just make sure that there was quite clear, they had clear instructions. It is somebody who isn't in the will or married to someone who's in the will. So you're going to get a friend, a colleague, a neighbour in. They don't need to know the ins and outs. They're not reading the will. They're not entitled to that information. They are literally just witnessing your signature. They have seen you sign that document and they're signing the name to that.
Fantastic. And I'm going to finish on one final question, which is really important. Should you put provision in your will for your pets?
Oh, yes, you can do. So you can give your pet to somebody else. It's a nice idea to check with them that they're happy to take the pet, first of all. You might want to leave them a sum of money to look after that pet as well, and just say they only get the money if they take the pet. It might be better to say, I'm giving my pet to whoever you're giving it to, and request them to rehome it. So if they can't take the pet, because it's a big ask to ask someone to take an animal, but you just have putting somebody in charge of either keeping it themselves if that's what they choose to do, or rehoming it appropriately. There are some charities, the Dogs Trust, the Cinnamon Trust, they will take a dog in. I think Cats Protection do something similar, and it's quite normal for people to give that charity a sum of money and ask them also to take the animal. So yes, you can make provisions.
Great. So I'm really sorry to everyone. I know there's still questions coming in and there's a lot that we haven't answered, but we are going to have to kind of bring that Q&A to a close. But I just want to kind of say, Lydia, thank you so much for your time today and delivering a really insightful discussion and Q&A. Obviously, any questions, as I've already mentioned, that we haven't had time to address, we'll collect all of these at the end of today's session. I'll send these across to Lydia and she'll then provide some responses that we can then circulate to everyone at a later date. Just want to say as well, for everyone who's attended, a massive thank you for being with us today. We hope you enjoyed today's session. Next up for NCL Discover, we will return in March as part of our NCL in Action initiative, which is focused on ageing. We'll be delivering 2 keynote lectures branded under NCL Discover as part of our launch day on Saturday, the 11th of March. The first one, entitled Can You Reduce Your Risk of Developing Dementia, with Professor Dame Louise Robinson. That's going to give us an insight into her research, which explores how we can address a number of health factors that can enable us to delay the onset of dementia in later life. Later on in the day, we'll be followed by Professor Karen Ross delivering her lecture, Blood, Bone and Crohn, the Menopause Experience from the Inside and Out, which will delve into her research project around the menopause journeys of various women. Both of these lectures will be delivered in a hybrid format, so you will have the option to join us either in person or online. Please get in touch if you want to find out more, or visit our website for full event details and the sign-up form as well. And that brings us to today's close. I'd like to finish by saying a final massive thank you to Lydia for joining us and hosting today's session, and to everyone else. Enjoy the rest of your day, and we hope to see you all at another event very soon.